fresh
No,
matter?
your lords, it's fresh matter.
Fresh matter, 38. Yes, I mean, pardon to make a mention, my lord. One CRLMC diary number 5630. Use the mic. Use
My
the-
lord,
yes.
diary number 5630 of 2024, I have filed on the ground of compromise, my lord.
Settlement?
Take it.
Yes, next.
I may pardon my lord, item no, next item no 39. My learned friend is there for the petitioner.
My lord.
In course of the day,
Yes.
item 39. In course of the
I'll pick it
day,
up today.
my lord, in fact, there is a connected matter. Let both the matters be taken up next week or in
Who else
any.
is there?
My learned friend is there for the petitioner.
My lord, it
In
will be
fact-
taken up on March 4th.
On the cause of compromise.
You please don't decide the date. Let the court decide the date.
Yes, sir.
You want an adjournment, we can give you.
Deeply obliged. My
Date
lord.
we will adjust accordingly.
My only contention that my lord may directed that both the parties should be present.
It is-
That
Compromise, on the cause of compromise.
Then you give the
Yes,
exact date.
there is connected matter. I am giving the number.
It is
Yes.
Let it be tagged.
Is it 23 matter or this
Twenty.
thing? 2023 matter? No, this one.
Ah.
The connected one.
Connected is 24. 24
connected
matter.
is 24, my lord.
24 matter.
Come in my
Yes.
Then it can be on March 4th, my lord.
4th March.
Deeply
Okay.
obliged.
Okay.
My lord, both the parties should be
Yeah,
present.
both the parties should be. We bring them.
Yes, my lord. Deeply obliged.
Yes.
Pardon, my lord.
Yes.
My lord, on 20th, there was a compromise and the lordship directed me to file a fresh CRLMC on the same day.
Yes, I told you.
I filed it and on the next day I mentioned it.
File a application for restoration. I said that you better.
My lord,
file.
I already filed it, but that case has not come because it has not been numbered. There is just a diary number on which I had mentioned on 21st.
But get it numbered. That at least you should do.
My lord, it has not been numbered till now. Hence, I pray for the lordship to fix another
I
date.
can't give a direction to the registry to get it numbered. You have to cure the defect.
My lord, item 36, it is on today's list.
Today's list.
Yes, but that fresh CRLMC that I filed, it has not been
Try
connected.
to get it number and tell me when the matter is taken up. I'll put it on Monday. I'll do it.
Lordship, Monday I won't be there. I'll be out of station.
First, go and get it number.
My lord.
We'll see. When 36 is called, then
My lord.
remind me.
My lord.
Next.
Pardon to make a mention only. Causing of proceeding, my lord.
Give-
Can you
give-
take it now?
give. Any more mentioning?
Pardon to
Online?
mention. Pardon, my lords. Item
Yes.
19 may I pray 1 week after, my lords.
Is it a fresh matter or afternoon? Fresh?
Fresh matter.
Okay, then. Yes. Call the list.
Item 1.
Yes.
Item on the petitioner filed his application for quashing of the proceeding. The offence relating to the POSCO Act, petitioner and the victim was got married and blessed with a male child.
On 1/10/2012.
How much will you pay now? 2016? 1,000.
Yes.
Allowed.
Obliged.
Yes. And you will have to appear on or before 15th?
Yes,
15th.
15th
Today
March.
also. 15th March. Okay.
Obliged.
Next.
Yeah, please, your lordship.
Yes.
This is a Belgium case, my lord.
When you got the bail?
On 21/2016, page 13, my lord, Annex 2.
Yes. And NVW is 10/1/2024. 1,000. Allowed.
My lord,
Yes.
500. Never at.
Okay, 500. Sorry. It's 2024. Okay, sorry. Yes. Next.
Item 4. Item 4, lordship, NWC issued on 10/1/20.
When you got the bail?
Lordship, on the police bail, lordship, here the order.
41. Hey,
ନାଇଁ 41 ନାଇଁ ହାଇକୋର୍ଟ ବେଲ୍ ଅର୍ଡରଟା ଥିଲା ତାପରେ
give the date. That's all.
ନାଇଁ ସେଟା ତ ଭୁଲ ହେଇଯିବ ଯେହେତୁ ପୋଲିସ ବେଲରେ ଥିଲେ 26/5/2016
He was on bail. He was on bail.
Plus.
And NVW issued on 24. Huh?
10/1/2024
Okay. 500. Yes. Next.
Item 5.
Pass over.
Item
Next.
6. Belgium matter, my lord.
Yes.
The petition was issued on 1/8/2023. Page 12.
Give me the date. Bail.
My lord, I may pardon the bail. Page 10 and 11, 7/6/22, he was granted bail.
Okay. 500.
My lord.
Okay.
Item 7. 7, my lord, this is Belgium matter.
What happened? 6.
My lord.
6. Okay. Hey, 1 minute. 6 is NBW issued on 23. Okay.
Oh,
7.
1/8/23, my lord.
Okay.
Page 12.
Yes. 7.
7, my lord, NBW issued on 08/2/2024. And the bail was granted on 30th January 2024. Single request.
You are very prompt. In the 24 only you have done everything. 500.
पुलिस क्या खोजियो हमें आगे पड़े
Item number 7, my lord.
And then you say 500 also.
My lord, item number 7, my lord. You should give you 1,000, my lord. As because my lord, they are not obey the order of High Court. High Court को सब data appear करे.
आगे देह खराब
Other
था।
than them, other than
But he is so prompt. Why to do? Okay.
Item 8.
Yes.
In this case, individual issued on 3/7/23, my lord. In the NI Act case, notice was issued on 19/6/23. Then thereafter, my lord, on appearance was at 3rd July 2023. But on that day, I was absent.
What was the check amount? The present case is arising out of 1 cc
1,44,000.
or 500. And arising out of 1
cc
case number 4 of 2021 under section 138A9. Since the petitioner did not appear before court on 3/7/2023, NBW has been issued. Was on or before 15th, 500. Yes. Next.
9, my lord.
Yes.
This is a Belgium matter, my lord. 21-23.
Now I think I should impose heavy cost. Why are you coming?
Not
Will take-
assistants are there, my
You,
lord.
where are your juniors?
In other courts and the
Other court you should go. Yes, when you got the bail?
bail was granted on 5/3/23.
Okay. 21/1/23 NBW. NBW. 500. Yes.
Item 10.
Yes.
May I please your lordship?
Yes.
The NBW has been issued on 12/6/2018, my lord.
Bail?
Bail I have stated in paragraph 4, my lord, 12/11/2012, my lord.
1,000. 500 each. 500 each.
Yes, my lord.
500 each. Okay.
Item 11.
11, may I please your lordship? The NBW has been issued on 23/12/2021, my lord. By the annexure 3, my lord.
In 11?
23/12/2021, my lord.
Item 11 you are talking about?
Yes, my lord.
Yes. Yes.
NBW has been issued on 23/12/2021, my lord. Annexure 4, my lord.
And bail?
Bail annexure 2, my lord.
8/12/1999.
8/12/1999, my lord.
21 ର କେତେ ଜଣ ଅଛନ୍ତି? 2 ଜଣ 500 each.
Yes, my lord.
Yes.
Item 12.
12, my lord. 7/3/23. No, yesterday my junior was there. Yesterday my junior was there. Item 10.
This is
That's Allah.
I will send my juniors.
you are coming in three matters you
Four orders, your lordship.
No, next time I will send my juniors. 7/3/23.
there should be an injunction order now. That's the only way. Bail.
Bail, 7/3/23, 22 bail, page 13, page 14, 20th January 24 NBW.
500. କେତେ ଜଣ ଅଛନ୍ତି ଆପଣ? କେତେ ଜଣ? ଜଣେ 2 ଜଣ ତ 500 each. 3 ଜଣ? 3 ଜଣ petitioner. 500 each.
My lord.
Okay.
Item 13. Item 13.
Pass out.
Item 14.
14 man of Belgium matter. NBW was issued on 26/7/2023, page 11. And the bail was previous bail was continued on 26/7/2017, page 9.
14, item 14.
Yes, ma'am.
Okay. Bail, NBW
26/7/2023, page 11.
of 500. How many of you are there?
1.
Item 15.
Item 15, lordship, Belgium matter, lordship, NBW issued on 4/3/2015, lordship.
15.
Lordship.
Bail?
They were released on bail on 26/4/2012, lordship.
How many of you are there?
1 person.
1,000.
Obliged.
Yes.
Item 16.
16, lordship, Belgium matter, NBW issued on 5/4/2022, lordship.
Now, bail?
Bail on 22/11/2016, lordship.
16.
16.
20.
22/11/2016.
22/11/2016 bail, NBW 5/4/2022. How many of you were there?
One person. One person.
1,000.
No, one person.
500. 500.
Item 17.
Lordship, may I please? Petitioner was earlier granted bail by the court bill on 21 November 2022, but there was some condition which was subsequently modified in CRL MA 329 of 2023 by this honorable court. And subsequently, NBW was issued on 31st
Right,
January.
first bail was on.
First bail was on
The petitioner was enlarged on bail on when?
28/8/2023 in CRL MA
Huh.
329 of 23,
And subsequently the bail condition was altered
altered,
by order dated.
order dated 28/8/23. Bail was on 21 November 2022.
Bail, first when you got first bail?
Yes, 21 November 2022.
21 November 2022, the petitioner got the bail. Okay. And the bail condition was altered by order dated
28/8/23.
28/8/20.
And subsequently,
And
NBW was
due to his absence in the, he did not appear in the court on
31st January.
31 ठीक है NBW 500. Yes.
Item 18.
Lordship, kindly be taken after 1 week.
1 week.
Yes,
Adjourn.
published.
Item 5 exam matter.
2 o'clock. There is a system has to be followed. That is your problem. You should have wait. You were sitting in the court. Where were you? Physically, you were there. Mentally, somewhere else. You must be counting money. What you got yesterday? Chalo, take 5. Bail jump mantra why too. Why will he waste his time? Again, he'll start counting money. Yes. When you got the bail?
27/2021, madam.
7/21.
Bail, madam.
NBW 7/8/23 500. How many of you are there?
I mean,
One.
one.
500. Okay. Okay. Yes.
Item 20.
20, my lord, the matrimonial dispute.
19 adjourned?
19 adjourned.
Mention. Okay.
This is the matrimonial dispute.
Past, they have not filed charge sheet. Past, they have not filed charge sheet. So Lordships said that by next date will not be filed, it will be considered.
What orally
21.
What orally translated in the court doesn't remember that. I don't know. It alludes to the benefit of whom I don't know, but that's the problem.
Now, question is, my lord, the anticipatory bail was filed by the ABLPL number 9982 of 2021. If first or second order was passed, he was directed to surrender, but he has not complied, and still today he is absconding. And no certificate has been given in this application. Number one. And the petitioner is the owner of the vehicle in which the contraband articles were transferred.
Why are you not?
I have avoided in the application about the previous bail application.
No, that's a part.
Yes.
If you don't cooperate, how the charge sheet is expected?
No, I am cooperating. I am there, my lord.
No.
Last 2 and 7 months.
How would I know?
In which way you are there, my lord?
No,
If-
have they issued any notice?
Why should I issue notice?
How come?
You have not complied the order of this honorable court.
Till date, they have
You have
not.
taken an order.
Till date, they have
You
not.
show
sent the
me any
scissor I
scratch
did
of
for-
paper where you have offered yourself to participate. You show me because you have got an order from the court. You should have written a letter.
That is not. That is first hour, second hour order was there with regard to
Why have you not?
bail application.
Why have you not?
I'm here. I am challenging the quashing of affairs on the ground for 2 and 7 years, 7 months. They are not filing the
The
charge sheet.
problem is if the accused doesn't cooperate,
No, there are 5 accused persons. I am nowhere concerned. My vehicle has been seized.
Custodial interrogation is much
And
more
the allegation is that they have recovered from the driver.
a driver
The
fled
driver
away from
absconded,
his spot.
what I can do?
Leaving
I'm
the
you are
not-
absent.
I'm owner of the vehicle.
What is the stage of investigation?
well, investigation is going on because of them. Why?
No, they have
why
not.
When are you going to
Chemical
appeal?
examination has not been made. The seizure.
Let them,
What will happen now?
tomorrow.
2 and
Well,
7
within
months.
15
But
days
see, the
investigation will
investigation is on. you have gone to the court for anticipatory bail.
No.
Anticipatory bail
That
court
I-
says that first hour, second hour.
Yes, ma'am.
You have not gone and appear. You avail that order. That indicates that had it been a clear-cut case of anticipatory bail, you would have definitely appeared. Now you are scared of appearing.
No, I'm not scared of.
Will you appear now? I'll record it.
Yes,
You appear? You appear?
yes. No, I'll be granted with bail. Otherwise, I'll appear and I'll send to the custody.
482. How can I give the bail? Can I upset the order which you have obtained?
No, if the lordship say that I will appear, he will arrest me. What will happen to this case?
That means you are not appearing. You are not cooperating.
Lord, I will surrender before the court will. That is no problem, Lord. There is no also time limit is there. First hour, second hour order was there, but
I can only do what I can do is only I can record
no,
that you will apply the order of the earlier bench.
Lord, your lordship can have glanced. I have enclosed the order sheet of the JMFC. Lord, repeatedly say, Lord, more than 12 orders have been passed. They are not submitting charge sheet. That is from the initial stage, from August 21.
Why don't you file charge sheet stating that he is absconding?
No, he
No,
is
they can file.
not a single accused was arrested.
What I can do?
Why?
If not, this is
Because
not a
when the police chased them, they left the vehicle and went away. Right, Millard? Now the person has applied for anticipatory bail and a CD was called for.
Anybody has got the bail?
No, nobody. And now the investigation due oblige to the honorable court and produce all the entire materials before this honorable court. After perusal of the entire CD, my lord, enter documents, witness statement, then my lord, first order, second order was passed. Unless until he cooperated, my lord, the investigating officer. How
Your
come the, my lord, the
Section 52 of the Odisha Excise Act they have applied. And Lord, it is not from my possession or recovery has been made from me. That is-
No question of passing in absentia. And you don't cooperate with the investigation. All the accused have fled away from the place. And the charge sheet is not being filed because of
Lord, what we have not, I will, if you, Lord, they will not ask anything. I'm staying
the
in the village.
best relief today, what I can give you is simply urgent.
Lord, that is for
Always,
last two occasions.
I
Last two-
tried it, all these things.
Last two occasions it has been adjourned.
What to
And-
do? Because you see,
No, Lordship, last occasion, your Lordship said that by 23rd,
imagine
they can file, Lord, charge sheet.
how can they file? None of you are apprehended.
Lord, have they
Will you
got,
think that's
Lord, have they got the chemical examination report?
yes, we
How
have
they
You
file?
don't go.
How they file?
What they are doing is not important.
Lord,
What you are doing is
Lord,
more
they have
important. You are the accused.
Lord, they have seized liquor. They have seized liquor. Have they
My-
gone for a chemical
My
examination or
lord,
not?
Lordship, I kindly say chemical examination report.
Suppose
Lordship, I kindly say.
Last occasion, my friend said that.
But now they are doing it.
last time I was there, my lord. But the report, my lord, is I sent a report.
You are in difficult position now.
No, that part is also one part. But Lord, my
Investigation is
Yeah.
going on despite the fact that none of you are cooperating. Investigation is still going on.
Lord,
You got an order. Unfortunately or
There are
fortunately,
four-
first hour, second
there
hour,
are
you
four-
don't go and appear.
Exactly.
What is
No, there are two vehicles has been seized.
Yeah.
One vehicle owner has been implicated. Other vehicle owner has not been implicated. Then,
Since your report has been got it,
but let them supply it.
I supply it. Am I
my investigation चलती है आपण जीवन में
Investigation goes.
आपण ଗୋଟେ କାମ କରନ୍ତୁ
Accusation-
ପେଣ୍ଟ ବାଜା वगैरह ଦିନେ ଟାଇମ ଦିଅନ୍ତୁ
ମୁଁ ନିଜେ ଯାଇ କହିବି ସାର୍ ମୁଁ ଆସିଛି ଇନଭେଷ୍ଟିଗେସନ ରେ କୋଅପରେଟ କରିବାକୁ ମତେ ଭିତର
ଆପଣ
ପୁରେଇ
ନିଜେ ହିଁ କୋର୍ଟ ଆସିଥିଲେ 438
ଆପଣ ନିଜେ ଆସିଲେ କୋର୍ଟ
ମିଳିଥିଲେ ଆପଣ ଯାଇଥାନ୍ତେ ମିଳିଲାନି police to call
Entry order.
and you are not visible anywhere where
Entry
the
order
police will
ଦେଇଥିଲା।
fetch you.
Entry order was there.
ତାଙ୍କ ଘର ଆଜ୍ଞା ଇଏ ଲordship,
Finally, your lordship. The
Entry
court-
order ଟାଙ୍କେ କାଇଁ କଲେନି
Entry order ବି ଡାକି ନାହାନ୍ତି।
entry order କଣ ଡାକିବେ? Entry order କଣ ଡାକିବେ?
ସୋମଟ ଯାଇ କହିବି ଆଜ୍ଞା ମୁଁ ସୋମଟ ବି ଯାଇଛି କେତେ ଥର ଯାଇଛି
This
ଆଜ୍ଞା,
submission
ଏ ଆଜ୍ଞା
is
ଶୁଣନ୍ତୁ
absolutely no
ଆଜ୍ଞା ଶୁଣନ୍ତୁ ସେ କହୁଛନ୍ତି ଆମେ କ୍ଲୋଜ କରିଦେବୁ ଖାଲି କୋର୍ଟ
all these things
ଆମେ କଣ କରିବୁ
all these things who knows better than you what your client has done
ବେକାର କଥା। Unnecessary question.
କଣ କରିବା I will take this thing on
Lordship,
personal
Lordship,
disposition.
kind of plans on merit. I'm not on merit.
I'll not pass that's for sure
Okay.
don't waste your time I'm not it can't be passed
No, there is no such allegation against me.
the investigation is still wrong and you are not cooperating you got an order first hour second hour you done you
Then
have
your
not
lordship, then your lordship,
and your allegation is
Your lordship may
Investigation is
dispose
not
of
going
the
on.
direction that
Investigation is
I will
going on.
appear and I will cooperate with the investigation, but he may not arrest me.
I
But
can't-
how, if you will arrest, what investigation?
यही कंडीशन रखिले आज्ञा से एका कोऑपरेट करिया कि मो
ନାଇଁ
अपील
ନାଇଁ
अरे कौन अरे arrest କରିଦବ କଣ?
ନାଇଁ କଣ୍ଡିସନ କରିପାରିଥାନ୍ତି ଯଦି ସେଇ ଅର୍ଡରଟା ନଥାନ୍ତା।
नो था
ହେଲେ
एग्जैक्ट
ମୁଁ ଯଦି ସେମିତି ଅର୍ଡର ପାସ୍ କଲି
ସେମିତି ତ
ଅର୍ଡରକୁ
appeal.
ଡାଇଲ୍ୟୁଟ କରୁଛି। Am I
Lordship
appellate court?
exercising 482 power.
Am I-
Not Lordship 438. Lordship's inherent power of 482.
See, this dialogue will not help you.
Lordship, I will cooperate with the investigation.
You
There is no problem. I am owner of the vehicle, sir. I am not, possession has not been recovered from me. No recovery not from me. If liquor has been recovered from me, then it's all right. My vehicle has been used by the driver. Where I am committing offense of 52.
एते बड़ा लॉस हे जाउची आपण
Section 52 है ना, देखो 52 रे कहला recovery by conscious
କେତେ
possession.
କ୍ୱାଣ୍ଟିଟି କେତେ?
Quantity मिलर 100 केते लीटर?
ନା ନା
100.
हजार
ମୋ vehicle 100 है. ମୋ vehicle 100 केते लीटर?
total quantity is
No,
1452
two vehicles.
steel foreign liquors.
मिलर 2 vehicles. My vehicle 184 liter, 84.320 LPL. And other vehicle is 207 LPL.
ଆପଣଙ୍କର କୋଉ vehicle number ଟା?
ମୋର ଅନୁସାରେ ହେଉଛି OD02Y9943.
9943
ତାର ରିକଭରି ହେଇଛି ସାର୍ 184.320
ମାରୁତି ଓମିନି vehicle.
ସେଇ ଗୋଟେ ଲାକ୍ସ ଅଫ ରୁପିସ ର ଭେହିକଲ ଟା ପଡିଛି 2021 having no responsible
You want
moving
to save
here.
him?
ଆଜ୍ଞା ମାଗୁଛନ୍ତି ଆଜ୍ଞା ମାଗୁଛନ୍ତି ଗାଡିର vehicle ରେଟ୍ ଦିଅନ୍ତୁ ସେ vehicle ହବନି 50,000 60,000 ନା କହୁଛନ୍ତି ଏକା 3 ଲକ୍ଷ
ନା,
ଦିଅ
ଏଇ ସମସ୍ୟାଟା ଆଜ୍ଞା ରେକର୍ଡ କରନ୍ତୁ ଏବେ ଏବେ କହିଲେ ଯେ ଆମକୁ ସେ ଡାକୁନାହାନ୍ତି କିଛି କରୁନାହାନ୍ତି ଏବେ କହୁଛନ୍ତି ଯେ ସେ
ସେଟା ସେତେବେଳେ କରିଥିଲେ ଯେତେବେଳେ ପେଣ୍ଡିଂ ଥିଲା ଆଣ୍ଟିସିପେଟରୀ ବେଲ୍ ଥିଲା ବେଳେ
ଡାକୁନାହାନ୍ତି ନାଇଁ ପ୍ରପରଲି ଡାକୁନାହାନ୍ତି ଆପଣ।
ଆମେ କାହିଁକି ଇନଭେଷ୍ଟିଗେସନ କୋଅପରେଟ୍ କରିବୁନି
ନାଇଁ where is that in the report you don't say anywhere Mr. Maharaj
Amen.
in the report you don't say anywhere from his vehicle what is the recovery.
No, that is an instruction before your lordship, but everything has been mentioned in the CD. CD is a bulky mallet, your lordship may kindly see.
ତାହେଲେ ଇନଭେଷ୍ଟିଗେସନ କିନ୍ତୁ ହେଇନି ବଲ୍କି ହେଇଗଲା
ଆପଣଙ୍କ ଗାଡିରୁ
ମାନେ
840 foreign liquor.
ସବୁ ପୁଣି ଲେବଲ ରେଜିଷ୍ଟ୍ରେସନ ସବୁ ଲାଗିଛି ଆଜ୍ଞା ସେଗୁଡା ସବୁ ମାନେ ସେମାନେ ଇଏ କରିବା କଥା ଯେ it is belong to which license also because batch number everything was there in the it is alleged in the affair. It will show from who is the owner of the
I'll simply dispose of saying
Lord.
that investigation is going on.
Yes.
And the petitioner may avail remedy under law.
Yes.
No interference at this stage and liberty is granted to you to approach at the approach. Beyond that, right now. The petitioner has filed the present petition seeking quashing of FIR. FIR.
This order will be again
FIR in Chandipur PS case number 108 of 2021 corresponding to GR case number 249 of 21.
may I pray Lordship may permitted to withdraw with liberty. I'll approach appropriate time.
The same thing I'm doing. I've recorded so that it will help you in the
Yes.
your statement. I'll record
Yes.
so that for the bail also it will be helping you take the observation from the court instead of simply asking for withdrawal. What we
Yes, sir.
whatever you say, I record it.
Yes.
So that it will be your argument in the bail stage. That's what I'm saying. Right on. Hon'Ble? Registered against him under section
52 Odisha Excise.
52
1A.
bracket small a bracket small I of Orissa Excise Act
2008.
and under section 34 and 120B.
Yes.
Right. Yes, sir. The allegation against the petitioner is he is the owner of a vehicle in which the
Foreign liquor.
foreign liquor, 100 bottles of foreign liquor was being carried by the was being carried. The petitioner was not.
No, driver has been implicated.
Petitioner was not at the spot. However, from the allegation, it is found that it is the driver who was driving the car at the time of the apprehension. At the time of the apprehension, the petitioner had approached the coordinate bench.
But nobody has apprehended. Nobody. That
When she is not apprehended. and it is further Mr. Maharaja appearing for the state submits that in fact nobody was apprehended from the spot and all the accused persons have fled away and all of them are absconding. That's the reason the investigation is not progressing at the pace it was expected to. It was expected. Let counsel the petitioner further submits that he had earlier approached this court by filing AVPL number
9982/2021.
And the coordinate bench has directed the petitioner to appear before the court below and apply for bail application, apply for bail, and which shall be considered as expeditiously as possible, as indicated in that order. In that order. I'm of the considered view that the present petition is premature. Therefore, no interference is called for. However, the petitioner, petitioner is granted liberty to approach this court at some appropriate stage, if cause of action survives. If cause of action survives, the petitioner at this stage to withdraw of the present case with liberty to avail remedy under law. He may do so on or before
15th March.
15th March by surrendering to the jurisdictional court. 15th March जाए अपने टाइम मिलेगा कि वितरण करी कर दूँ. How do you I can extend?
30th.
30th. It is virtually in anticipatory bail in disguise. And you go and investigation so that things will be.
No, we will cooperate.
Now at least go.
Yes.
Don't wait for band baja barat.
बॅन भारत करण्याचे पोलिस नौकर आम्ही काही खबर अरेस्ट करते
नहीं 30th तक अपन जाएगी करो तो so that charge sheet file is you, then you are free. Otherwise this will be hanging on your head always.
Yes.
Police is also in trouble if they are not able to proceed.
But till then no court.
That is what I said. Indicated. आपण 30 तारीख भीतर जाएगी सरेंडर कर जानतु police investigation करी 30 तारीख भीतर charge sheet file कर दो, then you will come out of the problem. Otherwise this will be hanging on your. Do it. Yes. 22
maybe.
Yes.
I'm approaching the opposite petition.
Yes. Quick for petitioner. Yes.
Seeking some time, Melchi. I'm for the opposite petty number in sub item 2, Melchi.
So item 2. What about the first item?
First item, I am your lordship was last item directed me.
You are for petitioner.
My lord.
In the first item. Who is the petitioner in second item?
Second item, I am also the petitioner.
You are also. Yes.
And the first item, your lordship was directed me to produce all the order sheet, entire order sheet.
What is this case? I have not directed anything, of course.
But this is the case, my lord, without giving me opportunity to file discharge petition. On the same day, the law and court below, your lordship, I may glance to page 10. Page 11 page 11.
11, yes.
On 19/10/2023, the record was transferred from the session judge to the assistant session judge. On the same day, I have appeared, bail granted, and same day, what charge was framed.
Is there any procedurally? Is there any this thing that
yes, but
it
on
will be done in
the first day of appearance, my lord, there must be some time gap.
Show me the procedure.
Yes, I am saying, my lord. Your lordship can have
The problem is if the court do the work little faster, you have problem. If the court doesn't do, then you have
no, my lord, this opportunity on the same day you
Show
can.
me the provision where it says that the day when you appear, on that day, the
226,
second
my
half,
lord.
that too second half,
My lord, 226, trial before a court of section file.
226.
225, your lordship can have also
1 minute. 225.
My lord,
Okay.
in every trial before a.
1 minute, 1 minute, sir. 1 minute, sir. 225. Mr. Maharaj, just see 225 is
Yes.
raising a legal question.
Yes.
Yes, 225.
In every trial before a court of session, the prosecution shall be conducted by a public prosecutor. Your lordship got it.
In every trial before a court of session, the prosecution shall be conducted by a public prosecutor. Yes.
Next, man, 226.
Hmm.
When the accused person appear or is brought before the court in pursuance of a commitment of the case under section 209, the prosecutor shall open the case by describing the charge brought against the accused and stating by what evidence he proposed to prove the guilty of the accused.
Yes.
Yeah.
Next, my lord, if upon consideration of the record, the case, and the documents submitted therewith, and after hearing the submission of the accused and the prosecution in the judge consider that there is not sufficient ground for proceeding against the accused, he shall discharge. Next, 228, framing of charge. If after such consideration and hearing so my humble submission, my lord, on that day, my lord, on 19/10/2023, it was received by the assistant session judge. As I am directed to.
Only the hearing of the case is contemplated.
Yes.
But it is not necessary that unless in the absence of a application under 227,
On-
hearing has taken place.
My lord,
And formal charge under 228 is framed.
my lord, it is a.
In that
It is a
11 case,
tribal-
Let him come, let him come.
It is a tribal by sessions.
Right.
So commitment was made. Commitment was to the session judge. Session judge transferred the file to the assistant session judge. And on that day, my lord, I have to go on the sessions bail. I have to renew my bail money. As because to continuance of the proceeding under the before the sessions, so I have to file fresh bail bond, and I have to for continuation of the proceeding bail. On that day, my lord, 1910, your lordship can have glance. The case record is received to them, transferred from session judge Noaigad and taken into file. Make necessary. Accused person name Udayonath Sahu and Jogesh are present. They also file a petition to continue on previous bail.
Right.
So my
Bail
continue
is accepted.
continuation. The accused person absent in court, both the additional defense are also be heard from the both sides later on the same
On
day.
the same day,
After releasing on bail, my lord, a charge must be framed in presence of the accused man. And your lordship may kind of glance to this. Accused person are absent in court. Once I have released on bail on the same day, later the Lord and Sessions what he has done, later has passed the order.
you got the bail and escape from the court immediately.
No.
The same day.
How can I, my lord? It is a procedure.
Accused persons are present. Accused persons are present in the court.
Person are absent in court. ଦେଖୁନାହାନ୍ତି ଆପଣ।
ମୁଁ ଦେଖିଛି accused person are present in court.
ତାପରେ accused person
କଣ
ଚା ପିଇବାକୁ
କରୁଛନ୍ତି?
ଚା ପିଇବାକୁ ଯାଇଥିବେ,
ନା ସେ ଚା ପିଇବାକୁ ଯାଇଥିବେ
ଚା ପିଇକି ଆସିଲେ ଆଉଥରେ କୋର୍ଟକୁ ଆସିଲେ,
on the same day ହେଇପାରିବନି।
where is the legal bar?
This is the procedure. When a case for the prosecution open, I have to call previous bail.
No, it is only contemplated that a hearing should be given, and hearing is given.
No hearing given.
It doesn't say that it should be adjourned to
My
the
lord,
other day.
Is there any objection? You lordship may kindly read properly.
there is no, my lord.
एक मिनिट
One minute.
କହୁଛନ୍ତି ଏଇଟା ଖାଲି ମୁଁ ପଢେଇ ଦଉଛି ଏଇଟା ଖାଲି ମୁଁ ପଢେଇ ଦଉଛି accused person are present in the court, both the learned additional PP and defense counsel are also present, heard from both the sides,
No.
heard from both the sides regarding framing of charge
It is a letter.
against the accused person.
My humble submission, my lord.
I understand.
It was done after letter, my lord, not in presence of the legal.
ये तो लिखा है ଆମେ continue ना
No,
ଆପଣ
1 minute, 1 minute. One minute. If you are saying it was letter, this
Yes,
written,
sir.
but you are alleging against the learned judge
yes
that in your absence all these things are recorded.
My humble submission, my lord. On the same day,
On the day when I was granted bail by the sessions court for continuation, on the
Is it
same
your-
day,
is it
one
your-
day, next day he can.
No, same day also you can do it.
No, cannot man.
কোন লেখা আছে সেই লটা কোডি ভাই দেখ দিল
225 prosecution.
Show me any
can-
judgment.
লেখা আছে এটি
Show me any judgment if you have.
Yes, madam.
Do you have any judgment?
I will show, madam.
Get some judgment.
I'll
Because
show.
from here, nothing is.
I will show, madam.
You get some judgment.
I will
It's
show.
a legal issue.
Maharaja,
But according to me, Prama Peta, I am not with you.
আপন টিচার দেখলে
I am not.
আদের কিছু লেখা আছে
Comer or.
No, don't exchange.
আরে মু আপনকো neither my intention to humiliate if you are so powerful and knowledgeable.
Anyway.
Express the matter.
Anyway,
matter.
Mr. Maharaj,
With all respect.
Malado, while
there is a legal issue.
Malado, while I am,
And this is a learning process.
Malado, while I am in defense side, my lord, in one case, Jashuda, same day charge sheet submitted, same day committed to the court of session, same day charge friend, within 15 days trial concluded. I came to hear in the appeal stage, my lord.
But you are-
appeal also disposed of.
you are-
Same day can charge friend.
That's right. I know that. This is
But
but he has
Same
proposed
day.
a proposition. If you have
the
judgment,
day committed to court of session, same day my lord charge friend.
same day can-
তাহলে 226 টা পড়াইব তো
ସେ কোন কইলা
তাহলে প্রসিকিউশন কেবে ওপেন হেলা তা
Appeal call पर अपन 226 রে
কেতড়ে
committed पर appeal call पर
তো কমিটমেন্ট আউট কোন না সেইদিন ফ্রেশ বেল লে গলি
हां बेल गल सेदिन ही परिबो भी
নাই ওপেন কোটি হেই জায়গা সেই অর্ডার
open kala para first order re सबटु top re open kala देखो top re
উপরে দেখন্তু
the record is received today, transfer from the session judge Nagar, taken into my file
হ্যাঁ
and make necessary entries, put the letter for appearance.
হ্যাঁ
That is opening.
ফর ফুট লেটার
And thereafter letter in the day,
হ্যাঁ তারপরে প্রসিকিউশন
তারপর letter in the year and frame the charges.
আগে 226 টা ইউ লর্ড মে আই রিড
Yes,
মে আই
one
রং মাই লর্ড
Please do that. Please do that. If you have.
When the accused appears or is brought before the court in pursuance of the commitment clause under section 20, the prosecution shall open his case by describing the charge. Where it was described?
Right. You tell me. Describing charge.
Describe the
Against the
charge brought against the accused and stating what evidence he proposed to prove the guilty of the accused.
That is the subsequent order in the latter part of the order. Yes.
That, after that, one day must be.
Where from you are getting one day in between?
same day
Same day without any.
One day thereafter the judge will be wiser.
No, wiser. One. I have to.
If you are reading a statutory provision, it
My
has to
lord.
be read as it is. It doesn't say next day it has to be done. He can do in the same day. Trials are supposed to be done continuously.
No,
That was the idea
yeah,
of session. What is the meaning of session? You tell me. What is the session meaning?
Who is?
What is the court?
Who is in the of the matter?
He has to
Deal with
assume
the
a
matter. Who is
case
to deal with the
and
case.
complete it. He comes to the session and complete a case. That is why the expression used is session.
Yes.
He is supposed to do this,
Well, I will show some.
which has been done in
I
this
will
case.
show some authority.
That is the idea of session. The
I will show
definition
the
of session is
authority
that. You just see you research on the subject, why the term session is used.
Yes.
209 টা clear আছে 209
Session is, he has to open a case and finish it case in one session.
Yes.
And one session is, one session means continuous proceeding.
I will show. I will
That
show
is the
it.
session.
I will show you this.
You get some. Is a proposition. You don't know.
I am from the OP two my lords. I have filed the protest petition, my lordship.
এইটারে
বাট এটা চলা এটা
সেকেন্ড
কেবে আপন
নেক্সট উইক এনি রে
partly heard to joldi kar do. Next week. But you get the judgment what is
Yes,
a
yes.
session. Session means we'll see on 20.
এন্ট্রি মডেল টু পয়েন্ট
Entry mode to that.
My lord, I am on receipt.
Yes.
I press on one at a time to take instruction. I appeared from 21 to 2024.
Sorry.
I appeared from 21 to 2024. I should press some time, one at a time to take instruction.
You want to file requisite.
Instruction.
You are for whom?
I am for opposite party.
Okay. Is somebody is appearing for petitioner?
My lord.
You are appearing for petitioner?
My lord, I am for the petitioner.
I seek some 1 week time. 1 week time.
He is seeking, the opposite side is seeking for 1 week time.
My lord,
130.
the matter will listed on next week.
Okay. Adjourn.
Okay.
Yes.
24,
Pass it.
25.
Please. This is a compromise matter
Yes.
and let notice for
Okay.
already marriage is dissolved by a mutual consent.
What is this matrimonial? Huh?
Yeah,
But
matrimonial.
490 days.
The petitioners, where is, no, the petition, at the
On my lord, I will see. Letter. Yes, 6, my lord.
is,
Yes, 6. I'm sure.
okay.
One letter sent to police.
Speak little louder or you use the mic. Yes.
One letter sent to Go police station by police sub-inspector Dungra police station, district Bhalsad, Gujarat, my lord, for interrogation of the petitioners. Petitioners are ready to cooperate with the investigators, only protection wants. Your lordship give protection, then
How can I give protection 482?
your lordship, with
No,
letter, kindly see letter.
Gujarat police has,
Yes, they are working labor, my lord, at Bhalsad.
where is that?
That is in page number
Pundi.
Yes.
No,
Only protection.
Page 6.
Page 6.
basic, na?
Page 6.
This is Ganjampuri. This is a letter written by
Written by
Police
the
Sub-Inspector Dungra Police
Police
Station,
Station.
District
Bhalsad.
Gujarat.
Good.
What kind of accordingly? You are nearby.
I am ready to cooperate with the investigation.
Accused, suspect, mentioned as below.
interrogation point this person is required for interrogation. They have
Offense.
paid for and 6 assistant of the local police team.
You have to go to, you have to avail the remedy into the jurisdictional court.
Yes, I am ready to go police station. I am surrounding go police station. Then
ऐसे कुटे limited protection देगी छाड़ जाऊँ तो सेटिंग सिटी आप डेट उठे फिक्स हो सही डेट से
Sir,
The petitioner has filed the urgent petition seeking intervention of this court because the intervention court on the petitioner has received a notice of summon dated 21/1/2024 from the sub-inspector
police sub-inspector Dungra.
basic Dungra police station, district Valsad, Gujarat.
number টা
calling
লিখি
upon him.
numberটা ভালপি টাউন পিএস পুলিশ স্টেশন
Calling
সিআর
upon,
নাম্বার
calling upon him for interrogation.
Yes.
In
CR case number
relation to case number
Bhapi town police station CR number.
Code लिखाई थी.
Post is first.
Post ये जो column होती है रे थोड़ा इलाज. हाँ? Bhapi police station CR number so. Who has given it? How have you received it?
Received
By post.
By post.
He has received the notice by post. By post. The petitioners are invoking the inherent jurisdiction of this court, seeking limited protection to the extent that they are ready and willing to cooperate with the jurisdictional police.
Yes.
Police. However, they need ready and willing.
Yes.
On instruction, the counsel for the petitioner submits that you would be appearing before
by 30th March.
Appearing before the concerned police station on or before 30th March. Till then, no coercive action shall be taken against the petition. Against the petition. It is accordingly directed that the petitioner directed that the petitioner shall appear before the jurisdictional police station in pursuant to the notice dated 21/1/2024 on or before 30th of March 2024 till then no coercive action shall be taken against the petitioners.
Remedies available. That remedy, whatever remedy is there, he avail. And he lots of apart from that, my lord, just forget this case. I may be excused for remembering. I'm trying to recall the memory of my lordship. That exactly the same question was put by my lordship when my senior SS Das was arguing this case. Exactly the same case. How the police from Karnataka came to the Odisha for apprehension of an accused, and your lordship put a question: where this procedure? Why they will not directly arrest the accused? Because the person come from Karnataka is a police constable. He was arrested from Odisha police, possessing contraband at of 4 kg 500 grams. My lord, my submission was that the outsider must have informed the local police before taking any action of the accused.
But here there is no directly.
No, they have taken the assistant. You also can see.
Where is that?
Yes, you are hereby specifically requested that accused suspected mention as below is required to be interrogated in CR number above mentioned.
Just go police.
Go police. That is my whole submission that day. That is why
You are right.
I'm excused for that. This came to my knowledge, so that this is the procedure.
Then you take this order, tell the go police will not arrest. You won't do that.
Yes, sir.
And this is only operative till 30th March.
Till 30th March.
Yes.
27.
27, may I please, my lords?
Yes.
My lord, I have filed this application for quashing of the criminal proceeding on the basis of amicable settlement, my lord.
Settle.
Yes, my lord. And the parties are also before this honorable court.
Okay, 498. Who are they?
I am appearing for the OP number 2 and 3.
Who is Jayant Pradhan?
Jayant Pradhan, my lord, petitioner.
Okay, Jayant Pradhan. And Sambaru Pradhan? Okay. Hon'Ble Pradhan? Okay. ठीक है. And Dilip Kumar Chakra.
Anyasa Chakra.
What is the terms of settlement?
My lord, they are living together, my lord.
Living together.
As husband and wife.
And tell the lady to take the child and go out. And legal appearance of opposite party number 4, informant victim, including her.
Milord, petitioner wants to marry
for
the
expression
victim.
of her consent. What is this?
Petitioner is wanting to marry the victim, Milord.
At the instance of court direction.
Milord, no opportunity, Milord. There is no opportunity also.
What?
Now,
Yes, read the prayer.
Milord, I have read already read.
Have you ever drafted this kind of prayer in your entire career?
No, Milord.
Then
I have not.
why are you
Sorry.
experimenting now?
Sorry, Milord, I have not drafted, Milord.
Just
That is
read
my.
it.
No, Milord, I am not ready. My junior has drafted, Milord. I have
But
admitted.
you must read.
No, Milord, I am
benefit of
admitted.
junior members of the bar.
See, Bartaman mo pakhre nai didin 3 din tole taku mo.
It's all right. No.
Milord, that
But
for
I'm just
that mistake.
asking you to read so that
No, Milord, I will
junior
not.
members will be benefited.
No, it will same to me also, Milord. I feel same, Milord.
Amend it.
Milord,
Amend it.
may I amend it, Milord?
Amend. Let's quote of record. You have
Yes, yes, Milord.
correct thing. How can I ask the victim girl to come and physically be
No,
present
Milord.
and give consent for marriage? All these things. What is?
No, Milord, I have no opportunity, Milord. DNA test is also corroborated. She is staying with her baby, Milord, at Utkal Barasram, Barampur. Both parties are ready. At the time of occurrence, she is minor, Milord.
The parents are creating problem.
Yes, Milord. Kulo Samaj is the creating problem, Milord. And one effort also made in the bail stage, Milord. That was failed. No police personnel has gone to the Utkal Balasram, where the victim is stayed, Milord.
You have,
Only lordships enter.
you have
with the-
implemented chairman, child welfare committee.
Yes, yes, my lord. Set a district child protection officer ko
Why
knock.
did you file a 226 petition?
My lord.
It is a fit case for 226. File a 226.
Liberty may be given.
That's better idea.
Yes,
Because it is not in the realm of a criminal
Yes, yes, my lord.
jurisdiction. It is in fact interference by third party in your matrimonial life, whatever.
My lord.
Write down.
Better application.
Write down. Shall I simply write it?
Yes, yes, my lord.
Withdraw and file a better
Mr.
application.
Party seeks to withdraw the present petition so as to enable him to file a better one. The petition is dismissed as withdrawn with a liberty to file a better petition under right provisions of law.
Obliged.
29.
May I please, Your Lordship? May I question of the entire criminal proceeding on the ground of compromise made?
May I pray for the certified copy of that annexer, my lord.
363, 66.
No, it's a written up.
Certified copy of, okay. Certified copy of the annexure.
Yes, my lord.
Annexure may be returned to Mr. Party. And the Rice is directed to return the certified copy of the annexure to Mr. Party, responsible for the petitioner, by replacing with the
Photocopies.
Obliged.
Under the present petitioner is the son-in-law of the informant. Son-in-law of the informant.
Yes.
And both are present before the lordship. And my lord and friend is appearing for the.
Where are they? They are there? Near.
Also filing compromise.
Godavari Rao.
The
Where
present.
is the girl?
Girl is rescued and married to.
Was also IO in another case, and he was asked to submit the case diary in that specific case on a specific date. On failure of the same, he had undertaken that he will deposit the case diary on the next day. But as he was discharging his duty, he could not comply it. Just 1 day delay, due to which, my lord, the session judge Fulbani, my lord, had issued a show cause notice. That is at annexure 1. If my lord may have a glance.
Yeah.
Turning page number 13. So, my lord, and the IO concern has also given its show cause.
175.
Yes, my lord, 175.
Not submitting. Omission to produce.
Yes. Omission to produce document or electronic record to public servant by person legally bound to produce it.
Where is sanction is required? You tell me.
Sanction is required, madam.
Sanction is not taken.
No, that is
Sanction is not required at all.
Why?
If this procedure will follow, then no public servant will comply the order passed by your lordship, even your lordship.
No, it is an offense.
No. Once a judicial, why the 197 CRPC, the sanction procedure, why it has been given? What is the real intention of the legislation? But the question is, in order to, but the harassing.
Do you have any judgment?
Yes, my lord, I have relied also. I have relied in my.
Let's see the 175 provision.
My lord, I have already opened and I have.
It says
Yes.
the opening sentence is the omission to produce
Yes.
document or electronic record to public servant by a person legally bound to produce it. Whoever being legally bound to produce or deliver up any documents to any of the public servant as such intentionally omits so to produce and deliver up the same shall be punishable with simple imprisonment terms which may extend to 1 month. He was a police officer.
Police officer.
He was supposed to file the charge sheet under 173 and he has
Malad
not
case
filed the
diary.
charge sheet.
No, not.
And documents, not produced, whatever. It is a violation of compliance of his statutory duty enshrined to him under 173, which he has not done. So therefore, 175 cognizance is taken.
Yes.
So he was the offense, the alleged offense is under the color of duty.
Yes, ma'am.
So therefore,
discharge, my lord, what the লেখা আছে in due discharge of his duty. সে কোন ডিসচার্জ করছিল তার ডিউটি রে
My lord, that is my
এটি কোন ডিসচার্জ হচ্ছে ডিউটি এক্সপ্লেনেশন আসুচি কি তার ইন্টেনশন আসুচি
you have judgment.
Yes, my lord.
For
Judgments, my lord.
what is actually really intention of the list.
My lord, my lord, I'll relate to the judgment. Just my lord may observe the area which the petitioner is serving, my lord. That is Fulbani, my lord. So, my lord,
Show me judgment for
Judgments, my lord.
175 sanction is required. As simple as that. Why? I mean,
সেইটা খেলে দেখা
my lord, the judgment which the learned.
This is a legal question we will examine, but
Yes, my lord.
You tell me.
My lord,
And he is raising the question. This is not coming under the color of duty.
exactly.
My lord, first on the face of it, my lord, 175. If my lord permits me,
I read the provision. He read the provision. You read the provision.
Yes, ma'am.
You show me.
It shows, my lord, that if a police officer, if any official omits, my lord, in the present case, my lord, I have not omitted. I have, my lord, given that the case diary, there was a delay, my lord. The provision talks about omits in complying any.
That is on merit again. you
That
will
is on
examine.
merit, my lord.
That's what you examine.
My lord,
You simply tell, do you have any judgment to support the case that for 173 prosecution against a public servant, namely a police officer, for
lord.
non-compliance of the provision, whether sanction is required
Yes,
My lord.
under 197.
yes, that is
My lord, if my lord goes to my grounds, although I do not have the physical copies of the judgments, my lord, but I have relied in my grounds, my lord. Ground K. Yes, my lord. The judgment of the apex court in Devaraja versus Sabir Hussain decided. The honorable court elaborately discussed about the sanction referring to number of its earlier judgment and finally concluded that the object is to prevent public servant from being subjected to vexatious proceeding for the acts which are done in the discharge of
So the police officer.
my lord. In this case, my lord, he is not a police officer. My lord, in subsequent judgment of Sangram Kesari Behra versus in M, he was a police officer.
Why have you not got these?
that fact and circumstance is different.
You are confident. You were so confident that by reading the provision you will
No,
convince
my-
the court, and you have no idea that Mr.
No,
Maharaj
yes.
is there to oppose you.
My lord, M also I have taken that ground.
Okay, I'll stay at
My
2 o'clock. Get the judgment and just see and stay. I need this only one judgment.
Sangram
that is
Kesari Behra.
Sangram Kesari.
My lord.
Okay.
My lord.
You get
I'll
it
get
at
that.
2 o'clock. Just I'll stay the proceeding and we examine this.
My lord, my lord, my lord.
We'll examine this. This is a legal issue. Let us examine.
Yes, my lord. Highly obliged, my lord.
Okay. No, 1 minute. Oh, sir is waiting. We'll finish it. Sir, which is your item? sir?
Item 31, next item, my lord.
We'll finish it up then. Okay. Yes.
For 31 is concerned, there are
Yes.
two sub items.
Yes, my lord.
And on the previous occasion, your lordship was pleased to detach both the matters. But again, it was attached.
What is this matter is about?
That is,
Doesn't matter,
CBI has
lordship.
filed two applications.
Yes,
One,
we have filed.
Mr. Naik is
Mr. Naik is there in the
We have filed it,
BC.
your lordship, it is our application. Your lordship may kindly come to 2909 of 2022 CRLMC.
the first one.
Yes, yes, your lordship.
Yes, the first one. Okay. What is
That-
this case?
Your lordship, there are in fact two. One is CRLMC 896 of 2023. One is 2909 of 2022. Lordship may kindly come to 896 of 2023.
896, right?
Yes. Lordship, the only limited remarks which we have is that the magistrate had taken cognizance for the offences under the PC Act without a valid sanction.
Okay.
Come to the last page of the order. He has taken cognizance for the offence under section 7 of the PC Act
Yes.
without, sorry, without a valid sanction, your lordships.
Yes.
Lordships, hence cognizance of the offence under the aforesaid penal section is taken. Issue summons to the accused persons who are on bail. Now this Saroj Das, your lordships, is a public servant. Cognizance has been taken under section 7. Your lordship may kindly come to section 19 of the PC Act for a moment.
Yes. Yes, 19. Tell me.
19 says that, your lordships, no court shall take cognizance of an offence punishable under section 7, 11, 13 and 15
Right. Yes.
alleged to have committed by the public servant except with the previous action. Now, the Saroj Das, your lordship, is the mechanical engineer of Paradip Port.
Yes.
Cognizance has been taken under section 7 and sanction has not been taken. In the meantime, your lordship, we have obtained the sanction and it has been filed before the lower court. So my limited prayer, your lordship, is that the matter should be remanded back. Fresh cognizance should be taken in the light of the sanction received. This is what your lordship, I am praying. And the section says that it has to be taken.
Yes. The procedural error of not taking
May I explain? May I explain? Cognizance order was taken without sanction order. That is my friends. And cognizance order was taken in favor of the prosecution. Then who is the aggrieved party?
But sir is not the counsel for Saroj Das. Your lordship,
Just a minute, Mr. Nayak, just a minute.
Yes.
Again.
Aggrieved is the accused who can claim that this cognizance order is invalid in view of the absence of the sanction order. Now the CBI itself said that the order is to be set aside, fresh cognizance should be taken. This is a very tricky question of law involved in this matter. Whether this petition itself is maintainable or not, that is a question which is to be decided.
There is no tricky question, your lordship. It is directly the section provides it. A sanction has to be taken and procedures, your lordship.
What Mr. Mahapatra is saying, that the cognizance is taken against the accused person, and the how the prosecution is agreed by that.
You will take benefit out of it because if no,
you withdraw it,
your lordship,
withdraw it, and then we'll see.
No, your lordship.
Why are you aggrieved? Cognizance is taken despite the fact that there was no sanction.
So your lordship,
there was no point for you to challenge it.
No, on that ground, your lordship will seek discharge or acquittal at the end of the trial. The proceedings will be vitiated, your lordship. If the statute provides something to be done in a particular manner, it has to be done in that manner, your lordships. If there is
that benefit inure to that benefit will inure to the benefit of the accused person.
Of course, he will get benefit. He will say that there is no valid sanction. Let the prosecution be the proceedings be quashed, or he may seek for acquittal also. And moreover, your lordship, the counsel for Saroj Das, your lordship, I think is not Mr. Mahapatra. Somebody else is there. He will make the arguments. No court shall take.
I'm representing Saroj Kumar Das.
Yes. No court shall take cognizance of an offence. The statute provides it. Punishable under section 7 to have been committed without a previous sanction. If the statute provides a thing to be done in a particular manner, it has to be done in that manner, no matter who is aggrieved, your lordships.
So that's what they say, that why have you not done?
Sanction was awaiting you, lordship.
That's the question they're asking.
Lordship,
who submitted charge sheet? The prosecuting agency submitted charge sheet. They know the law.
Your lordship, kindly see the charge sheet.
And they called upon the court to take cognizance.
Lordship, kindly see the
Again,
charge
they
sheet.
said that we are aggrieved.
Lordship, kindly come to page 47.
47. Okay.
Yes. Page 47, paragraph 16.41.
47. Okay.
Yes. The sanction for prosecution against accused public servant have been sought from the competent authority, which is awaited. So it was awaited how it could have been done, your lordships. The moment it came, before that, he had already taken cognizance of the offence, your lordships. Now sanction is there, we have filed the sanctioning order. What is the problem if he considers the...
You want to submit that when the sanction order was abated, the trial court was in a hasty to take cognizance. That's what you want to say.
Taken cognizance, he was in haste or not, I can't tell you, lordships. But when it was awaited, he had taken cognizance. And from his conduct, it is reflected that he was in haste. Now, your lordship, the matter can be remanded back. Sanction order has already been filed. What is the problem in taking fresh sanction in lieu of the section 19 of the PC Act? How they are aggrieved if the matter will be remanded back?
My lord,
if cognizance has been taken, your lords, sir, let me complete. If
I have a say. Today we are asked to appear before this court in connection with the matter, and I think that all of my friends, they appeared in respect of each opposite party. I suggesting if Mr. Nayak will concede, then it will taken up some other day. I will point out the law.
Now it can be taken up.
Now the raised objection which you have raised, he has now adequately answered to the extent that he says that once the prosecuting agency goes and says to the court that the sanction is abated, And what was the hurry for the trial court to take the cognizance immediately without waiting for sanction?
Exactly. We'll examine the order sheet, how under which circumstance the court took the cognizance. What
To
is
that
the,
extent, the trial court is wrong.
yes,
It
yes.
should have waited till the sanction order
Yes,
stays on record.
it depends on the factual aspect. Merely submission is not sufficient. What was submitted before the court, whether complete charge sheet was submitted or charge sheet was submitted, keeping investigation open with a request that
That's what he is showing.
Your Lordship, I give you 2 minutes time, Your Lordships. Your Lordship, the other.
The sanction order was awaited, and he apprised the court that, see, please
Yes.
hold on, sanction order is awaited.
And it is reflected in the charge sheet.
that, you proceeded and
Yes.
took taken cognizance. Now it is annulled to the benefit of the accused person.
yes, yes.
You can't blame the prosecution.
Sharp and-
No, I am not blaming. I am saying that we have to examine the entire fact because it is the
Sir cannot examine. Your Lordship, I
factual
give you 2
aspect.
minutes
This
time.
is the-
Listen, Naik, notice
Your
was
Lordship, I give you
issued.
2 minutes time.
Answer.
2 minutes. Your Lordship's last date of hearing this 8/9.
I am also appearing to my lord.
Got a minute. Got to Siddhartha, got a
I am
minute.
also appearing to
Your Lordship,
let it be
CR
taken
name
up
is
from other day.
2909. Got a minute.
Mr. Pal is speaking.
Piklomo. Your Lordship, CR name is 2909 of 2022 can be taken up some other day. As it
No,
was
that's
dated.
what the senior counsel, Mr. Mahapatra, is asking the same thing. He says that since notice has been issued, the parties are appearing.
Today.
They are entitled to be heard.
But your Lordship,
they are raising some question here.
But your Lordship, Mr. Mahapatra is not appearing for Saroj Das.
My
So
lord,
Mr.
I am appearing.
But
But why is answering for Saroj Das? He should answer for other accused. The person who is appearing for Saroj Das should make it clear that how he is aggrieved. If the matter is remanded back at a fresh in the light of
when I said Mr. Mahapatra means I have not said junior Mahapatra or senior Mahapatra. Junior Mahapatra is also joining with senior Mahapatra to ask time.
So this matter is pending, Your Lordship, as far as 2909 of 2022 is concerned, it will take some time. It can be taken up some other day. But as far as this
First week I am keeping, they are entitled because notice has been issued, they are entitled to be heard. Let us see. I put it, you tell me which date suits you.
7th or onwards and there?
7th.
7th. Whatever my learned senior will tell you, Lordship, I have no.
11th. 11th.
I am a great fan of Mr. Mahapatra, Your Lordship, from childhood.
And all of us learned from him only.
Yes.
No, he's well acquainted with the law and the judgments of the various high courts. He is a very prudent boy. And I wish that he will be a future giant in the criminal law, like your father.
No, he's doing very well. He's doing well.
My lord, although I have entered
And it's
appearance.
very encouraging that the youngsters do.
No, he's doing well.
Very.
I was very minutely his submission, his behavior.
He prepares well and submits.
Yes.
Yes.
My lord, although I have entered appearance in both the matters, my lord, but my name has not been reflected, my lord.
The counter, if any, can be filed.
11th.
Your Lordship, counter if Your Lordship,
Both
counter
the
if it can be
matters,
filed so that I can
both the
also file.
matters will hear. They will file. Joydeep Pal is also saying something.
Yes, my lord. I am also appearing for to accuse my lord. Let it be taken.
No, we don't want to hear you.
11th,
We don't want to hear you in the VC. You
I
have to
want
come here.
to visit my lord. My lord.
Come on.
Basically, that is why I am my lord, my lord.
He must be there in his village. So.
Since, no, my lord, in my chamber.
Okay. 11th.
I am in the chamber, my lord, not village.
11th. Okay. Thank you.
Obliged, man.
My lord.
8-1.
Yes, ma'am. Order number 3 dated 8/1/2024.
Huh.
And at para 2, my lord,
Hmm.
of the order,
Hmm.
after the second line, para 2 of second line,
Yes, sir.
after the word being, it should be inserted as Chandua PS case number.
No, no. The investigation in the present case is still on. At this stage, the petitioner who is of 25 years old.
No, my lord, para 2.
Acha, para 2.
Para
The
2,
complaint of opposite party number 2 FIR came to be registered against PS case number so and so.
being PS
Acha.
case number. This is Chandua PS case number. Chandua. PS before the word PS case.
I understand. It is written by you. Where is the police station number? PS case means which police station? This is an application for modification of the order dated 8/1/2024. In para 2, although the PS case number is given, but the police station name is missing. Therefore, the petitioner seeks modification of the order dated.
Another para is there. Man. Para 5 reviewed.
Para
5.
same copy paste. In therefore, the petitioner seeks modification of the order dated 8/1/2024. In para 2 and 5, the police station name has to be prefixed with the word PS case number 69 of 2023.
Another
Case
mistake
number
is there.
what is that police station number? Chandua
PS.
Chandwali PS.
Chandwali name. Chandua.
Chandua.
Yes.
PS.
69 of 2023.
Prefix. The word PS
Chandua.
number 69 of 2020.
Yes, ma'am. Next matter at para 5.
Yes.
Yes,
Same problem.
No matter, different problem. At para 5 matter, in place of passing of FIR, passing of, and in place of FIR number 69 of 2023, it should be Chandua PS case number.
Everything will be changed.
Yes, madam. Thereafter, my lord. Thereafter,
out of
pending,
case is there.
pending in the court of law and SDGM.
Huh.
SDGM should be, my lord, law and JMFC 1 cog taking Baripada. In place of SDGM, it should be JMFC 1 cog taking.
But see your prayer. Page 10.
My lord.
Page 10, your prayer.
Yes, ma'am. Page 4 of my.
Page 10 of your prayer.
Main page.
Main petition.
I
You have written SDGM, what to do?
I will correct that.
You commit some mistake,
Sorry,
and my
sir.
staff commit another
Sorry,
mistake.
sorry, ma'am.
And I am here to correct it.
Sorry, ma'am.
SDGM की जगह से JMFC करो.
JMFC 1 cog taking.
Huh? And the petitioner further seeks leave of this court to correct the name of related court below mentioned in the page in the prayer clause of prayer clause and ऊपर भी लिखती है क्या? ऊपर भी क्या लिखती है? That's the problem. हाँ ऊपर भी क्या? SDGM.
Yes, ma'am.
In the first paragraph also
Yes,
SDGM prayer भी as
I'll-
SDGM
I'll-
सब कुछ अगर SDGM
I'll correct it.
mention in the petition. In all the places in the petition, all the petition. This he may do so during the course of day and 1% base. Yes. Next.
33 city case number.
By correction करो सी correction tomorrow everything is wrong.
No, madam.
What can I do?
City case number is there. Arising out of city case number 536 of.
The most funniest thing is you file a petition, it was allowed, Thereafter, you move an application, now correcting the main petition.
I am.
And the very fact that I'm allowing it itself, you should be happy. I should have imposed heavy cost on you. I'm not doing it because my staff has committed a mistake. Therefore, I'm not doing it. Henceforth, if this kind of things happens for modification application, I'll impose heavy cost. I'm not doing this time because one mistake is committed by my staff. This is not, permissible. In the High Court level, what are you doing? Yes, 33. If you have a file color, then you keep on correcting. Yes.
Yes. Thermal petitioners challenged the order of cognizance dated 19/5/2021.
Which is the annexure?
Annexure
Cognizance order.
Annexure 3 page 26
Yes.
For the Commission of Offence 447 294
What
50.
is wrong in it, cognizance?
Well, my respectful submission before your lordship is that
Yes.
here the petitioner has a ice factory and boundary wall prosecution case. Admitted fact, prior to the demarcation of the land, petitioner has a ice factory and with boundary wall. She alleged that I have encroached the boundary wall, and before demarcation already installed. Allegation is that they abused in slang language and gave life
This
threatening.
is
But
along with all this. Yes.
and it is a civil dispute. So 447 is not made out against the petitioner, my lord. Because already he has not entered into that is an existence. Boundary wall and ice factory.
I'll just simply issue notice. Let us see, find out.
Yes.
Because now you are there, your ice factory is still working.
He is still working.
How much you have encroached his land?
That is their allegation, but I have not enclosed, my lord. That
You
is
find
the-
any civil suit, anything for demarcation? There may be some problem in demarcation. You might have encroached little bit in his land.
That is, my lord, she has stated I have enclosed, but as per instruction.
How much you have encroached?
That is, my lord,
Decimal.
plot number
Kete
Zero
encroach କରୁଛନ୍ତି according to allegation.
ମୋର କିଛି ଜାଗା ଲେଖୁଛି
Demarcated by local RI, and RI pointed out that the Kailash Godo encroached 2 decimal acre.
that is before that I have already existing boundary wall and ice factory.
What can I do? You have the allegation is the RI has demarcated. He finds that you have encroached 2 decimal of land, and whether you have encroached or RI is correct or not correct in 482, I can't examine. You have not initiated any civil proceeding. You should have asked for civil proceeding for declaration something. You have not done. How
But
will I decide it?
so far as the offense under section 447, my lord. Sure.
If the RI says that you have encroached, you want to
That is my
construct wall in that area, there will be always fight. What to do?
My 447 says, my lord, criminal trespass, my lord, whoever enters into, my lord, I have on that, the enters into, that is from the date of incident, they have not, my lord, enter into the.
Encroachment means you are.
That is prior to the, my lord, since long,
So
my lord.
this is in a cognizance stage,
See, lordship issue notice.
I simply issue notice. A 2 decimal, why don't you leave? You are a
Exactly.
businessman.
is
See, you have a big plot. Why you are encouraging this 2 decimal? Or there maybe some misunderstanding. Just sort it out.
That is misunderstanding.
Maybe some misunderstanding. Issue notice the petition, the opposite party you have at the instance of opposite party number 2, FIR number so and so. Shall I tell the police station also here now? FIR number so and so in PS number so and so is registered against the petitioners. The allegation in the FIR is that the charge sheet has already been filed and
Yes.
cognizance has been taken by the court below by the order dated 19/5/2021. The allegation in the prosecution alleges against the petitioner that the petitioner has allegedly enclosed 2 decimals of 0.2. 0.2 decimal किधर कोई ना? 0.2 decimal of 0.2 decimal ना किधर कोई रहता?
Decimal from the plot of 318.
0.2 decimal of land of the नहीं कौन लिखना? Land.
The petitioner enclosed.
Comma, which is the genesis of the entire dispute. Next paragraph. Issue notice to the opposite party number, returnable so and so, and in the meantime, proceeding before stay for छोटा matter aggravate करी कौन फायदा? कि मना सुन settle कर दो. I am staying the proceeding.
Yes, Bella.
On the ground that you will at least
Settle. Yes.
settle.
Yes.
So that it will not.
Kind indication ऊपर दे दियो. There is the land council or the petitioner submits that there is chance of settlement in the issue, settlement in the case. Hence, he seeks indulgence of this court. तापरे issue notice करके stay करती.
Bless.
March last week. Now I've stayed it go on.
Yes, yes.
Now, don't take the certificate copy and encroach further.
No, my lord. They're already there.
I've got a stay for 2.
No, my lord.
0.2. Now I'll.
No, my lord.
Don't do that.
No.
34. Yes.
My lord, in this case, my lord, SR has pointed out some 2 defects are there.
What are the defect?
Defect number 3 and 19, my lord. Defect number 3 and 19. I'll remove.
You want to cure?
Please. Monday it may come, my lord.
Monday may not be possible, but you cure it, it will be listed. If there is urgency, we will see what can be done. You are challenging what?
Cognizance order.
Cognizance order. Aram se do. Yes. Next.
35. For an adjournment.
Adjourn.
That's
why?
Not senior will argue this matter.
You are also senior. Argue what is this case?
That's the question of FR.
Huh? What are the offenses?
Offenses are under section 342, 294, 323.
307. Where is the injury report?
I have not annexed.
You have not filed anything except FIR. Investigation is still on.
That's it.
Investigation is still on. Then? April pay कर दिया. By that time, investigation will be over. Charge sheet will be filed. April last article. Yes. 36 somebody will mention. You.
Well, 36 in the meantime, the number has come.
Number has come, na?
CRLMC 511.
Is the present matter along with Monday, Tuesday.
My lord, any day after 28th, I won't be available till 28th.
29th.
29th.
20. Please along with the number.
511 of 2024. CRLMC 511.
29.
29th.
You come with the parties and all.
I'll come with the joint affidavit as well as both the parties. Grateful.
That day we'll finish it up. Okay.
My lord.
37.
May I please? In this case, I have challenged for passing of FIR, my lord. But I will allow some time to make the informant as a party. I have not made the informant.
And counsel the petitioner seeks leave of this court to include the informant as opposite party number 2. Now you do it. You want to do?
Monday I will file.
He may do. He may implead opposite party number 2 and file the consolidated memo of parties. Okay. Yes. 40.
I praise the Lord, sir. Here, my lord, notice was issued, my lord, arising out of a matrimonial.
In this case, my lord, beg to pardon.
Opposite party, you are.
Opposite party, Mr. Tukuna Mishra will appear as he has instructed me to
tell the, my lord, instead
Any
of
adjournment?
I pray for adjournment, my lord, on that ground.
Yes, madam, my respect, I will file an adjournment petition because I am staying at Canada.
Third week for, ठीक है?
Will-
Remove application. Date में तो.
21st April, sorry, March.
Yes.
41. 41, I'll take fresh notice to
41?
opposite party number 2. I'll take fresh notice.
The Land Council for the petitioner submits that he would take. Acha, oh. Says that you have not filed requisite.
Yes, I have filed that was written as insufficient address.
Pursuant to the order dated 31/1/2024, the petitioner had filed the requisites.
Yes.
However, service on the opposite party number 2 could not be effected because of the change of address.
Yes, ma'am.
No,
No, my lord. In complaint petition, whatever address he has in written in
petition. Land Council of the petition submits that he attempted to serve the opposite party number 2 on the address given by the given in the complaint petition.
Yes.
However, he has now obtained the fresh
notice.
Fresh address.
Yes.
Fresh address. He may amend. He may add the fresh address in the cause title and take steps to serve opposite party number 2 by next date of hearing.
Your Lordship, I have filed an IA. That is 399 of 24.
What do you want?
For amendment of one line has been omitted in ground number 1. That should be inserted. Your Lordship, kindly have to see IA number 399.
IA number 399.
Yes.
Land Council got the petitioner has moved this present application seeking amendment in his petition to replace certain sentences in page 4 in paragraph I of the petition. The petition is allowed and he may carry out the amendment as per in the application.
Consolidation petition filed tomorrow. Tomorrow, no, on Monday, my lord.
And adding the fresh address.
Yes.
Land Council for the petitioner may file amended consolidated petition amending the page 4 of the petition.
Right.
In page 4 of the petition and also adding the fresh address of the opposite party number 2. Okay.
Interim order continue.
Interim order to continue. Yes.
42.
Yes.
Yes, madam.
Here, referee for quashing of the proceeding, also here alleged offences are 370, 374, 420, read with 34 IPC, and order section 25 of the Interstate Migrant Workmen Regulation and Employment and Conditions of Service Act, 1979.
This is only at the FIR stage. You have annexed
No,
only one.
even though occurring in 2022, in the month of November, police is yet to file charge sheet, nor.
So, what do you want at this stage? Let the police investigate. You have only filed one annexure, that is the FIR.
Yes. No, police is yet to file charge sheet.
Let him file. Let them file. Why have you come?
And the Lordship, see the allegation, the ASF police.
The allegation, we don't know if allegation is correct or not. Let them verify by investigation. How will I check? Am I police station or?
That is.
It is only the charge sheet is filed. You have filed a petition only annexing the FIR.
No charge sheet is filed.
No charge sheet is filed.
Yes.
Only FIR.
Yes.
So the investigation is still on. Let us see what is happening. Whatever you have, you go and
No, in fact, so far at present, so far the FIR is concerned, the ASF police before the ASF Belpara police the informant. While she was performing duty, she got some information that.
Everything is correct.
Yes, madam.
But at this stage, what the court can do?
No, that is there. You also see one just moment. Moreover, you also see from the spot, the driver along with 2 other persons were present. I was not there. My implication is.
Then you arrange something so that I can go with you to see this spot.
No.
That's the only thing I can tell.
That I not.
You have annexed only one FIR.
Yes, yes, Bill.
You want quashing of that. Charge sheet is not filed.
Not yet filed, no.
Investigation is going on. You want to take me to the spot. Where from I got the spot? You tell me spot map. Show me.
At page 9 of the FA. Yes,
Is there any-
I don't understand.
You are
well.
taking me to the spot.
Yes,
Where is the
I-
spot map? Show me.
I do understand well. Because by the time occurrence took place, I was not there. Driver is there, and two of the inmates of the vehicles were there. Allegations there, they were.
You are absolutely correct. I am not disputing that. But can I examine these things? Where from I'll get all these things from the record? You have not filed anything.
No, except the charge, except the FIR, nothing is, no progress, nothing till date, my lord. That is whatever documents was available with me. Your lordship, see, one more thing I bring it to lordship's notice. On interrogation, so and so they have stated that the petitioner has paid 40,000 each on their financial need, but now they are them to proceed to Visakhapatnam, Andhra Pradesh, they will pay a huge amount. That is what the allegations are. Your lordship, no, due to dearth of work in the locality, mostly from West Odisha, people are very often used to migrate different parts of India to eke out their livelihood.
The case, but
And in order to meet those social ceremonies, during Nuakhai, Dasara and all these things, the people are offered with some money.
law has to take its own course.
No, that is there. My lord.
What to do now? Tell me. You withdraw it. I give you liberty to approach at the right time.
No, may I pay for one thing, my lord? Accused persons are 4 in number. Your lordship, see the affair
Yes, yes.
against the driver of the vehicle and 2 other persons. Those
What do you want? You tell me.
And so far I am concerned, my name is serial number 1. In fact, I am not on bail. 3 other persons are already bail. I have got the copy of the order. 3 of the accused persons are already bail. I am not on bail. Your lordship. That is what your lordship
You
died.
have missed another court.
I do appreciate. I do understand. Well, you also see the bail order.
Then counsel for the petitioner seeks to withdraw the present petition, keeping the liberty, reserving his liberty, reserving his right to file appropriate proceeding at appropriate stage. He submits, the learned counsel for petition submits that except the petitioner number 1, all other petitioners are
On bail.
No, you only one petition here.
Petitioner 4 in number, 3 are on bail. I am not on bail.
Except the present petitioner, all other accused persons are on bail. Therefore, he seeks indulgence of this court. Indulgence of this court. The petitioner may surrender before. What shall I do? Shall I protect him for some time and go?
Also, in fact, I am a.
Learned counsel of the petitioner submits that he would avail the remedy under law by surrendering to the jurisdictional court.
Yes,
on or before 30th of April.
Yes, yes.
And 30th of April. 30th of April.
30th of March.
30th of March. 30th of March. 30th March. 30th March. Full stop. The petitioner petitioner on instruction. He says, shall I issue notice or dispose of?
Dispose.
The petition is disposed of with the above observations. The petitioner no course actions shall be taken against the petitioner till 30th March. So as to enable him to avail the
Remedy will not allow. Yes, that much obliged.
It is anticipatory by this guy. But this is not the jurisdiction of this.
Yes,
In
I
fact.
do. I do.
But these are labor people and unnecessary.
No.
That is the reason I gave indulgence. But don't get encouraged by
No, no,
moving
no.
this kind of-
Absolutely not, my lord. Yes, okay.
Yes.
The notice has gone. AD not it.
Yes, sir.
Notice has gone.
Notice has gone.
Yes, my lord.
Let's see, check it.
AD not returned, my lord. Neither AD nor on bail.
Opposite party, added opposite party 3 and
Yes,
opposite party number 2. Sufficient.
report actually.
Requisite file is in it. awaiting, awaiting, the service on, opposite party number 2 and 3, matter is adjourned to. Yes. 44.
Milord, maybe. Next step.
Service. Yes. 44. Yes, Mr. Pradhan, that correction.
Yes, that my lords, I have prayed for deletion of para 4, 5, and 6. Your lordship kindly see the para 4, my lord has observed.
Which part you need correction?
Yes,
Which
my lord.
paragraph you
Kindly see the paragraph 4.
Para 4, no?
Para
In
4.
the present case, for
Yes,
the
that in the
self-submitting-
present petition for the self-sum relief, the petitioner has repeated another petition without disclosing that he has already approved this court, making self-prayer by CLMC no ethic.
172 of 24 was filed
My lord,
later.
yes. Yes, my lord has passed the order in 172, but my case is, my lord, 27.
Right. The application for modification of the order dated 15/2/2024 is filed by the petitioner, seeking modification of order date, modification in para 4 of the said order. The para 4 reads as under. Mr. Pradhan, para 4 ittu uttar devo. Mr. Pradhan submits that in fact, the present petition being CRLMC 27 of 24 was filed earlier in time than the CRLMC number 172 of 2024. Therefore, there was no occasion for the petitioner to disclose regarding the filing of the CRLMC number 172 of 2024, which was later in point in time. Therefore, the recording of the court in para 4 regarding the concealment is mistaken of fact. Accordingly, he seeks a correction. Taking into the consideration the aforementioned facts, germinating from record, the para 4 of the order dated 15/2/2024 may be replaced by the following para. The petitioner, had earlier filed. Petitioner, after filing the present petition, para 4, invited Kumar Talakuru, after filing the present petition, had also approached this court by filing another petition being CRLMC number 172 of 2024 for self-sum relief. In the said CRLMC 172 of 2024, the petitioner has not disclosed regarding filing of the present petition, namely CRLMC 27 of 2024. Therefore, it is made clear. Therefore, it is made clear that insofar as the present petition is concerned, there is no concealment regarding non-filing of. There is no concealment. The idea is see, para 4 पढ़ला बेलकू लागुची Mr. Pradhanଙ୍କର कोन mistake ହେଇଛି लागि that feeling comes. I don't want that he has not done anything, and because his petition is earlier than 172 file कला से disclose करिया
That is true. So how would it
हाँ.
You also can turn to the affidavit of this case. This case, this affidavit has not been shown by the advocate clerk or any other thing. But the petitioner himself, he also made clause 3. Affidavit clause 3. That's what it.
Yes.
Affidavit clause 3. Number of proceedings pending in the High Court or would be instituted. Lekala no. Again same no. again same. He should have come with a clear heart. This is the procedure. ଆପଣ ଏଠି mention କରିବା କଥା 4 ଲେଖନ୍ତୁ କି 3
ଟିକେ
ଲେଖନ୍ତୁ.
ରୁହ ବାବୁ
Number of proceedings
ଟିକେ
pending in
this is the
High
new
Court
format has come
and would be
मतलब he this is the new format affidavit has come ଟିକେ ରୁହନ୍ତୁ
But I tell you, Mr. Pradhan,
ଆଜ୍ଞା
your client is very mischievous. Very mischievous. Maybe out of desperation, he must be filing Romani case because he is suffering from cancer and all.
Yes, yes. This,
So,
this is number one. My lord has rightly imposed cost in earlier case. Earlier case, my lord has imposed 5,000 cost. Rightly, my lord has imposed. I am not in that. But Mr. Maharaj is saying this is the affidavit. But this is the affidavit has come. Typist is doing type.
Let us not postmortem
Yes,
further.
yes,
Unnecessarily
yes, yes.
Put an end to it. छोड़ो काम खत्म.
ମୋ senior କୁ ମୁଁ କିଛି କହୁ ମୁଁ କେବଳ କହୁଛି ଯେ ତମେ ଏଟା
Better ଜିନିଷ
when he
technical ଜିନିଷ why sir going to the technical thing?
this is the procedure adopted by this honorable
It's all right, but when he mentioned, I only saw para 4. There is maybe a reflection on him, so therefore I entertain it. I've clarified it. It's all right. Just put an end to it.
Yes, yes. But so far as cost of rupees 5,000, my lord has imposed in para 6.
Page 14. For cost you pay. Cost for you, what cost?
No, without instead of cost, my lord.
5,000 is insult to you.
No. There is no difficulty in making payment to the bar association. That's absolutely fine. But so far by this way, I will not make a payment to the bar
Have you
association.
already deposited?
Yes, yes, I have already.
Mr. Pradhan further submits that although cost of 5,000 imposed on him
In earlier.
and the imposed in this petition was not called for in view of the clarification. However, without going into the question whether the cost was rightly imposed or wrongly imposed, he submits that he has already deposited the amount, and it should not reflect as if the office of Mr. Pradhan has committed any error by concealing the filing of the earlier petition. That is taken on record and the application disclosed. I have taken it record since you have deposited. There shouldn't be any reflection on your office. That's the idea. Okay.
45.
My lord.
In this case, my lord.
Last occasion, your lordship directed to file the 13 petition accused statement. That yes, that I am just notice was issued to party for further hearing today in the court below. Statement recorded by the court below, which is the court for and meanwhile, yes, 313 statement has already been recorded.
Absolutely.
And the notice was issued also to the opposite party number 2, 3, and 4. That was repeat.
I had a problem, I'll tell you. I had a problem. The victim girl, PW1, mother, father, everybody was examined. That time, this girl was staying with the boy. They compromised marriage. A cross-examination taken place. They did not cross-examine, thinking that, okay, we are staying and all. Thereafter, something might have happened. The relationship has gone bad. They lost that opportunity of cross-examination. Now they are not staying together. They could not avail the opportunity of cross-examination also. Therefore, they moved an application, saying that during that period of time when a cross-examination is going on, we were staying together. So we had a good relationship. Therefore, we did not cross-examine. This is the position. I have recorded the last order, just see.
And the accused was also inside custody when the victim was examined.
So now this is the situation. So he has a right
And
to.
when the petitioner was inside the custody.
Right. Upon last order, देखिए. Last
And
order I have.
these are the photographs kindly have elapsed.
What is the
They are
position of
married,
service?
legally married. And now due to pendency of this case, my lord, they have been separated by the police and the parents of the victim.
I have already, this is the marriage certificate. Huh?
And then there will be separate.
So
That risk is always there.
Appeal.
And I asked the same question. You are bargaining risk now. Calling them to the witness box. Now the relationship is not good.
Not good.
And she will implicate you. They married, the photographs are there.
If the victim girl will come, then
that is why I have issued notice.
Yes.
Chalo, awaiting notice, adjourned. In any case, I have stayed the proceeding. We'll see.
They said the time bits of the other direction.
No, I have stayed already. Long back I stayed.
Yes, sir.
And see the photograph. Just see.
Yes, sir.
Photo.
But
With that.
period नहीं बदला.
But what to do?
The administrative discuss को लगता है बहुत problem.
चलो adjourn करो April पे देखिए.
My lord,
Interim order to continue.
Yes.
My lord, if your lordship will direct to the police to produce that girl, then matter will be over.
No. That for very difficult. Rather you advise your client to build up a good relationship. See, by police force and then you put whatever relation little bit you have, that also will spoil. That we should not aggravate. Give little time so that they may patch up themselves. I have stayed the proceeding. Let it go like that so that with time things may change. Keep it in April. April last week at Grokho. Time middle at least they will think of.
And you try your level best to convince the girl. In the meantime.
Otherwise, the life of both the girl and the
My
boy.
lord, the girl, but he is staying in other places. But they are not talking for petition.
That is the reason I have stayed it. Let the proceeding be stayed. The time will heal everything. Yes.
Urgent copy. In course of today, otherwise I am facing illegal.
No, I have stayed the proceeding.
I have stayed the proceeding copy of.
Copy to
Copy.
In course of today.
Yes.
Tomorrow.
Yes.
Tomorrow holiday.
Yes.
In this case, my lord, last occasion, lordship referred the matter to mediation center, my lord. The mediation has been fixed on 13th. Mediation has been fixed on 13th March, my lord.
12 March.
The matter was referred to mediation center, and mediation is in progress. Hence, awaiting the mediation report adjourned to March 13
April first week.
First week of April.
Interim order to continue.
Interim order to continue.
Privilege.
47.
Yes, item 47. That here, in action of that JFC contravening disposal of the 1cc proceeding. Everything out to 138 proceeding. Last occasion also was pleased to issue notice to the accused.
22 raw matter.
Yeah.
Where is the opposite party number 2?
No, he is yet to
Opposite
appear.
party 1.
Last year also was pleased to issue notice. Requisite was filed. He is yet to appear.
Service
Noting कुछ ना है नोटिस आई चाहिए
नहीं wait, you are the complainant.
Yes, ma'am.
I can't say it also.
No, not stage requirement.
Let them come, awaiting the outcome of the awaiting the service on opposite party number 2.
On 1 mile. 1 is the private, 2 is the state. 1, OP number 1.
One sing
Yes,
opposite
ma'am.
one. Written ଆଉ ଗୋଟେ ଡେଟ୍ ଦେଇଦିଅ ନହେଲେ କରିଦବା ଆଉ ସର୍ଟ ଡେଟ୍ ଗୋଟେ ଦେଇକି କରିଦବା ନହେଲେ I was thinking that if he will come, we will try to settle
Yes, yes.
138 matter.
Yes.
What is the check amount?
5 lakhs, madam.
ଯଦି ସେ ବିନା ଦେଇଛନ୍ତି ତ ନାଁଟା ଡିକ୍ଲେୟାର କରିଦେଲେ
ଟିକେ ଦେଖିଦିଅ
Bina reflect ହେଇଛି ନା?
Power ଟିକେ ଦେଖିଦିଅ Power ଅଛି ବୋଧେ
का ना ଅଛି?
Yes, Mr. Prashant Kumar Naik is there.
ନାଁଟା ରିଫ୍ଲେକ୍ଟ ହେଇନି ଲିଷ୍ଟରେ
Name is not reflected.
ମୁଁ ସେଥିପାଇଁ
Name
କହିଲି
of Mr. Prashant Kumar Naik
Naik and Associates.
and associate may be reflected
Yes.
in the.
I'll also intimate you, let's keep it next week.
हाँ कर दियंतु किसी settlement करियो next week आडू केते लगे दियो and you inform 29.
Yes, ma'am.
You ask him so that he can seek instruction. If anything happens, it's all right, or I'll send it to mediation.
As you also.
Finish it up.
Let's keep it in 29th, Miller.
29.
As you also. I'll intimate the other side.
You have to intimate. Otherwise,
Yes, I will intimate, ma'am.
Name reflect. And passover. How many passovers are there?
ଦିଟାଳୁ କହିଦେଇ just ଫଳ ଦିଟାଳୁ ଆସିବ
May I pray for one thing, my lord?
No, he is there. That we can do.
My lord, for petition, may I pray for one thing? Since Mr. Naik is appear, his name is not reflecting the hospital. Name reflect- As you lordship. Yes, much obliged.
Yes. Yes.
I got the judgment.
Research.
He got the judgment. You give him.
Already gave, my lord.
I have already only because my younger friend is taking hardships to get a relief, but he has under the decision. Though it is not given to this case, lawsuits sometimes stay.
Okay.
And he used to be
Very
directed
just see. This is the best, prosecutor you ever get. Yeah. Item number
Item number 30, my lord.
20
30.
30.
Yes, my lord.
It is a legal issue, but you have to further
My lord, my lord.
try hard.
The petitioner will be satisfied this court by.
I'll write. What was the case? Let us see now.
187 sanction is required in not.
The petitioner has filed the present petition seeking quashing of the cognizance order dated 25/1/2024, passed by
Learned SCJM Fulbani.
Fulbani in
2C
bracket
2
C, CC case number 23/2024. This is correct?
Yes, my lord.
I'll not modify it.
My lord, that is correct, my lord. Running page 17.
Page 9. Page 9. Further check it up. Okay. Cool, sir. The petitioner is being prosecuted for having committed offense under section 175
Of
IPC. Petitioner is petitioner is a police officer who was investigating a case, and the allegation against him is that he has not filed the charge sheet within time.
My lord, case diary.
Case diary within time, leading to the registration of the case against him. Mr. Mahapatra and the counsel for the petition submits that in order to prosecute a public servant under section 175 CRPC, the sanction is essential under the
Under section 1.
sanction is essential. He relies upon a judgment of Sangram
Honorable
Keshari Behra versus so-and-so, to substantiate his submission. Issue notice to the opposite parties. Mr. Maharaja accept notice. Waives notice. Mr. Maharaja further submits that this is the petitioner has raised a legal issue. The judgment he cites is distinguishable, is not matching the facts of the present case. Let counsel for the petitioner, Mr. Mahapatra, let counsel for the petitioner seeks further time to place on record the judgment of place on record the judgments
Which is relevant to the present.
Judgment relevant to the facts of the present case.
Facts and the law.
Facts of the present case. In the IA, I.
Facts in law, my lord.
In the meantime,
Only
the
facts.
proceeding pending before court so and so is till.
Highly obliged, my lord. May I pray in course of the day because my lord, tomorrow is a holiday, so urgent certificate copy.
Course of the day, subject to condition, they will type it out and I can sign.
Another condition may be imposed. Last time I asked him to ask her junior to appear. His junior, my lord. Despite that, we had not allow her to
there is-
appear in case.
there is
Some
no-
cost
She-
in,
she's
in-
standing there.
remind me on the other, here I can't
That
impose
quasi
cost.
case, well, compromise case.
Okay, how many cases are there? Huh? 2 o'clock, you have one matter, no?
No, my lord.
All
I-
settlement matter.
One
One bail jump and I'll sit for 10, 15 minutes because 3 o'clock that reference is there.
Yes, sir.
So we'll, okay.
Highly grateful, my lord.
You got bail on 3/11/15.
2015.
NBW 18.
NBW 18.
How many of you are there? One.
One minute.
How much?
1,000.
1,000.
Your lord's is
Standard. Okay.
24.
Yes, 24.
Yes, my lord. I may please, my lord. The offense alleged is under section 318, 80, sir. And the specific allegation of the prosecution that the court record has been taken away by one advocate, namely Biranchi, from the court office and his advocate clerk. And subsequently, I was dragged into the matter. I am also an advocate, and I was dragged into the matter as because that Biranchi stated before the colleagues that he has taken the file on my instruction. This is the only allegation against me, and there is no material available on record that I was anyway involved with the file in questions. Neither I am appointed for anybody.
Let us read it.
Pardon, sir?
Page 25. Come to page 25. Gist of the case is that Court record.
Yes, my lord. One miscase, election miscase file has been taken away by that Biranchi and his.
Then whether you have taken the record or not, whatever allegations are, that has to be tested in the trial only. What can be done?
That is a fact, my
Maybe
lord.
because you are advocate doesn't mean that it will be quashed.
No, I am not telling like that. My lord, my point is, in no manner I am involved with the removal of the file in questions. Only allegations against me that Biranchi says I got an instruction to take away the file from my side.
Hey, what way you are involved, what not, that is can't be tested at this.
Yes, my lord.
Can't be tested at this.
So my submission is, when there is, right now there is no material to say that I am involved in this case until and unless the trial is over. So I should be given relief, and the NBW which has been issued against me should be withdrawn, my lord. That is my prayer.
It is only NBW issued.
Only NBW.
What you are challenging?
My lord?
What are you challenging? I will set aside the NBW order. You go and face the trial.
Yes, NBW has been issued on 25th of April, August, my lord.
You were on bail. You were in bail, huh?
No. After taking cognizance of the offense, as I was not arrested during course of investigation, the London court was pleased to.
The petitioner submits that during the course of investigation, he was not arrested and the charge sheet was filed with the police. Subsequent to filing of the charge sheet on 20th May 2023, the court below has taken cognizance for the offense under section 380/34 IPC against the petitioner. Against the petitioner. And
25th admittable as you mentioned.
25th.
Yes, my lord.
On 25th, where is that? 25th August.
25th August.
On 25th August 2023, the SDJM Baleswar has issued NBW against the petitioner. As he was not present in the court. On the concept of the petition. As he was absconding. Sorry, not present in the court and was absconding. Let concept of the petitioner on instruction submits that his client would appear before the court on or before 20th of March and seek remedy available to him under law, taking into consideration the aforementioned facts and set aside. I set aside.
29.
That is the LBW order, 20.
29.
Yes.
But questioning of the affair on the ground of compromise, my lord.
Compromise.
The
parties are there.
Parties are.
They married.
Now the victim married to somebody else.
Someone else.
Because he is the second son-in-law, my lord. The victim is the
fourth daughter of the.
Who is Pradeep?
Pradeep is the.
He happens to be the
second son-in-law.
No, what is the relationship? Let us understand.
Relationship?
Narahari Raut is Narahari Raut.
Narahari Raut is the father-in-law of the accused, my lord.
He is the accused.
He is.
He married to the second daughter.
Second daughter, my lord.
Oh, victim is the first daughter.
Victim is the 4 number jo na? 4 number jo.
But the victim is the sister-in-law of.
Sister-in-law of the accused.
He kidnapped the victim. Accordingly, the affair has been registered.
But now that victim is also married.
Victim is also married and she have 2 children. She have 2 children.
Okay.
Suppose victim complain करता
Geo IP repairing. Oh, ये online रे. ନା ପ୍ରୋବ୍ଲେମ ହଉଛି କାଲି ଆପଣ ଝିଅ କହିବ ମୁଁ ତ ଚାହୁଁନଥିଲି କେମିତି କରିଦେଲେ।
ନାଇଁ, ସିଏ ଡରୁଛନ୍ତି ଜୋଇଁକି ଯଦି ଜାଣିବ ଯେ ଝିଅ ଏଇଭଳିଆ ଘଟଣା କରିଥିଲା ବୋଲି ସେ ଘରଟା ଭାଙ୍ଗିଯିବ।
No, we will cause it unnecessary. We will not spoil the.
ଦିଟା ଛୁଆ ଅଛନ୍ତି।
We will cause it. Unnecessary notice will go and she will know her life is ruined. As it is, she was a victim.
କାହିଁକିନା 7 ବର୍ଷର ଝିଅ ଅଛି ସେ ସଦାବେଳେ ମା ପାଖରେ ରହୁଛି ସେ କହୁଛନ୍ତି ଯେ ଯଦି ଆସିବ ଝିଅ ବି ଆସିବ ବାପା
The instance of opposite party number 2, the FIR number so came to be registered against the petitioner. The allegation against the petitioner is that petitioner, no, the petitioner is the son-in-law of the opposite party number 2. The allegation against the petitioner is that the petitioner had kidnapped his sister-in-law. Kidnapped her sister-in-law. Good, sir. Sister-in-law. The opposite party number 2 states that the victim daughter, his victim daughter, has already married. What is the name of the husband of the girl?
girl ତାଙ୍କ ସ୍ୱାମୀ ନା କଣ? ସଞ୍ଜୟ ବିଶ୍ୱାଳ।
ନାଁଟା କହିବା ପାଇଁ ଜୟଙ୍କର ନାଁ ଜାଣିନାହାନ୍ତି ଆପଣ?
ସଞ୍ଜୟ ବିଶ୍ୱାଳ ସାନ ଜୟ ତ ସଞ୍ଜୟ ବିଶ୍ୱାଳ
one Mr. Sanjay Vishwal. One Mr. Sanjay Vishwal, happy and leading a happy marital life. She is blessed with two children also. Therefore, the opposite party number 2 submits that he doesn't want to proceed again.
ହଁ ଯାଅ